Hogan informs judge of XRP Army's investigative work. I believe Judge Netburn follows some XRP users on Twitter or perhaps even YouTube. Previously, I didn't believe it, but now I can see you, Judge Netburn. Although Judge Sarah Netburn won't reach her final decision on the privilege issue until after September 28. Yesterday was a significant development in the SEC Ripple dispute. The conference room was full, as the XRP holders had promised, and the judge was obviously seeking clarification regarding the SEC claims of the deliberative process privilege, DPP, despite his earlier insistence that the agency's internal documents had to be turned over because they were important for the fair notice defense. The judge's discussion of the objectiveness or subjectiveness of recklessness with SEC lawyer George Tenreiro was the focus of the hearing. She inquired, Mr. Tenreiro, is recklessness an objective or subjective standard? A lot of evasion was used in response to the direct inquiry. In a video, attorney Jeremy Hogan made the remark, "To start with, Judge, let me just first start off by saying, but eventually, even the SAC had to acknowledge that the criteria was objective. Why is that so important? Exactly. Because the SEC internal discussions are 100% meaningless if the standard was an objective one. And what did Brad Garlinghouse know about whether XRP was a security when he sold it? Army of XRP to the rescue, the SEC was far from agreeing on what counts as a security or not in the new asset class. According to statements and videos about the agency's views on digital assets, ETH and XRP from 2017 to 2020. One illustration is a video we recorded and transcribed here that was unearthed by the XRP community. The judge appeared to be familiar with these tapes. That would be relevant if all the SACC commissioners were out to lunch and discussing how they are all uncertain about whether XRP qualify as securities or not. Someone said, that was the pinnacle of the hearing in Mr. Hogan's opinion. Okay, I'll admit it. Matt Solomon, a lawyer for Ripple, cited the Novak Sachs case in saying, if the underlying law was unclear at the time, even to the SEC, then the alleged violation could not have been so obvious that the defendant must have been aware of it. Jeremy Hogan claims that the judge concurs that the paper's relevance is sufficient to disprove the SEC claim of privilege. She has requested an in-camera review because of this. This means that the SAC will give Ripple lightly redacted copies of the privilege papers while giving the judge complete, undeleted copies of every document so that she can reach a decision on the matter of privilege. In the interim, Ripple has submitted a motion to require the SAC to respond to questions on how the Hawaii test applies to XRP without evasiveness. The plaintiff has been dodging the defendant's questions about the situation, even going so far as to contradict prior claims. The privilege dispute has been dragging on since April, and Judge Sarah Netburn has arranged a telephone conference for today to resolve it. The SAC has asserted that the DPP, deliberative process privilege, protects its internal records, including the agency's conversations about the nature of XRP and ETH. That has already been rejected twice by the judge, because the court views those records as being important to Ripple's fair notice defense. The outcome of today's hearing may very well be a significant victory for Ripple. According to the defendants, those records will reveal the agency's inconsistencies in its decision-making throughout the years, demonstrating that the SAC did not give XRP a fair warning that it might be seen as a security. The general impression that there is a lack of regulatory clarity in the SEC communications has already been established by William Hyman's deposition. Two bombshells in that deposition have been identified by Jeremy Hogan, a lawyer well-liked by the XRP community, and they potentially enhance the fair notice defense. Yesterday, the SEC submitted a move to force Ripple to provide tapes of particular meetings. Prior to a significant former Ripple employee testifying in her deposition earlier this month, Ripple never informed the SEC that Ripple routinely recorded staff meetings, claimed the plaintiff. Judge Sarah Netburn stated in a letter that unauthorized recordings will be looked into, and anyone found to have engaged in such actions may face criminal penalties. The conference call has been maxed out by John Deet, the attorney for the approximately 20,000 XRP holders who submitted an application to intervene in the SEC Ripple lawsuit. There can only be 4,000 listeners during the hearing. The SAC has already expressed displeasure about how well attended these hearings are, given the high level of interest in this litigation. Participation by thousands of investors has already proven to be very disruptive to Judge Netburn's court conferences, John Deaton said. Let's fill the conference call to the brim, but leave them with nothing to gripe about. Lawsuits' importance for the digital asset market is demonstrated by the fact that holders maintained their word and filled the conference call to the maximum amount as requested by lawyer John Deaton. The judge has reminded the public that it is illegal and punishable by law to make video or audio recordings or broadcasts. Judge Sarah Netburn first inquired about whether Brad Garlinghouse believed the SSE relied on objective or subjective foreknowledge that XRP was a security in 2013, to which counsel Matt Solomon responded that it had to be obvious to a reasonable person. This question referred to the SEC aiding and abetting claim regarding the complaint against the individual defendants. According to Ripple's legal representative, Mr. Garlinghouse could not have known what the status of XRP was if it had not been evident to the SEC prior to the filing of the case in December 2020. Then Matt Solomon brought up the SEC use of the deliberative privilege process, DPP, defense to prevent the defendants from receiving its internal record. Mr. Solomon contended that the plaintiff had gone much over the top with regard to DPP and should be forced to provide Ripple with those papers. Judge dissatisfied with subtle interpretation of SEC, the judge then turned to the SEC lawyer, George Tenrero, and inquired about his understanding of the reckless standard for the plaintiff's claim of aiding and abetting. First, Mr. Tenrero criticized Ripple's analysis and asserted that only precise, straightforward foreknowledge matters. The judge questioned, but was Mr. Garlinghouse's action objectively reasonable? He could sit before a jury and say he did or didn't know, was the SEC's subjective response. The judge cut the SAC off, saying, but that's subjective. Mr. Tenrero reiterated himself in response to the judge's question. He did not provide an unbiased reading of Garlinghouse's claimed aiding and abetting of an unregistered securities offer. The SEC attorney then expressed concern that Ripple wanted to collapse everything into digital asset law, look internally at everything, and swing the door open, all of which would be very damaging. Judge desires to view privileged documents for herself. Judge Netburn questioned why the court couldn't look at that and if it was necessary to assign dates to the deliberations or if they were ongoing. According to Mr. Tenrero, there are pre-decisional and post-decisional procedures, and the privilege logs provide several examples of various concurrent deliberative processes. The judge interjected, "How am I supposed to know all that?" After deciding to peruse the SEC materials behind closed doors, Mr. Tenrero cautioned the judge to proceed carefully, warning that it might be very prejudicial. The defendants won't be reviewing them, the internal documents. During the in-camera review, Judge Netburn reminded the SEC. Thus, the judge will continue by independently analyzing the SEC's internal records before making a decision about the deliberative process privilege claim made by the SAC. After September 28 should be when the decision is made. That's it for now. Thank you and see you in the next one.